Good afternoon. May I reserve 5 minutes for rebuttal?
Why, sure.
May it please the court. My name is Chad Dunn, and I represent Cuffs Industrial in this appeal and petition for writ of mandamus before this court. The district court, or the circuit court below, entered an order denying a motion for new trial after a non-binding arbitration proceeding. The arbitrator had decided the issues in the case based upon competing verdict forms submitted by each of the sides. Cuffs moved for a new trial based upon both questions in the defendant and in the plaintiff's forms.
And it's not technically it's not a new trial, which in our parlance suggests that you've had a trial per se, as opposed to this arbitration, correct? So
that's true.
You ask for a trial de novo.
The statute requires you to ask for a trial de novo. The Florida Supreme Court rule changed the vernacular to a motion for trial. In either case, the motion, which is at page 376 of the appendix that Cuffs filed, asked for a trial de novo.
And you only sought a trial de novo on the underlying damages claim, not the liability. You wanted to accept that, and the lien foreclosure, correct?
Yes, with one exception. Cuffs sought trial on liability and damages on the fraud claim. On the other, what I would call contract.
Which was not.
I'm sorry?
Which was not pleaded.
It had not yet been pleaded in the pleadings, no, but it was tried by consent before the arbitrator.
Well, you argue that, but there wasn't a fraud claim provision in the Duke's verdict, advocated verdict form, correct?
That's true.
And similarly, you had pleaded fraud as an affirmative defense, had you not?
That's also true.
Counterclaim. So when this evidence, if evidence came in on the fraud, that would have been admissible on your affirmative defense of the counterclaim, correct?
It would have been, and as well as the claim.
So there's pretty long series of case law that says if it comes in for any other reason, you can't basic claim that it was tried by consent on the fact that it came in.
Well, we think this particular issue is controlled by precedent from this court. The Bacon case says if the arbitrator ruled on the affirmative claim, then it's to be a part of the trial de novo if a party asks for it.
And so the arbitrator ruled on the affirmative claim because it filled out the verdict form that you. Yes,
and because there's no evidence in the record or in the arbitration
it didn't find any different damages. So correct? The arbitrator is all the damages in all the lines were the same, correct?
The damages were found only on the contract related promissory estoppel type claims, not on fraud.
Okay, let me come to a more basic question, and that is, how come you wouldn't have an adequate remedy by an appeal from the final judgment in this case?
Well, at that point, the case will have gone to trial on all of the claims.
Or not. The judge could have said, well, the judge here said, well, you get your choice, right? You get your judgment if you want, or I don't know what else the judge said you could, but the judge was not going to give you a trial de novo on just damages. Oh, you get a trial on every claim, correct?
Right. The judge gave Duke a freebie, basically. Duke gets a trial on everything without being at risk of having to pay any attorney's fees.
And how come an appeal from a judgment after that trial would not be an adequate remedy for you?
Well, for one, Cuffs would have incurred all the time, money, and effort to go through this trial process.
Yeah, but in the analysis of what's an adequate remedy, the additional cost doesn't come into it in the jurisprudence.
And with all due respect, it's a ministerial duty. The statute says shall in 7 different places.
Even so, I've written that, on mandamus, we treat this as a man. We know this doesn't really fit in any of the 9.130 cubby holes, correct? So this is a mandamus proceeding, I think.
But the court said.
I've written that mandamus doesn't require that you show irreparable harm, right? But it does require that you show you don't have an adequate remedy otherwise.
What the second district decided in Johnson is that the statute says shall. It's a ministerial duty.
They do a ministerial duty, but enforcing that, but what you have to show is you don't have another adequate remedy to enforce it. And what I'm saying is, how come an appeal from a judgment wouldn't be the adequate remedy?
On that point, I just have to respectfully disagree. When it comes to a statute that says shall, there is not a necessary showing of adequate remedy later. Now, we don't.
No, there's not a necessary showing of irreparable harm. You don't have to show that you were harmed by the refusal.
Being put to
mandamus, I think you have to show that you don't have another remedy.
Being put to trial on this case, on all of the claims that Duke wants to proceed with, without Duke having to have any skin in the game under the statute. Duke has no concern about a 25% improvement on its verdict and fee shifting under the statute, is irreparable harm. Essentially sending Cuffs off to an arbitration proceeding and effectively leveraging the binding nature of that arbitration proceeding to get Cuffs to waive the right to have claims heard by a trial is itself irreparable.
Do you have any cases though that says you can get a trial just on damages instead of the, and leave a arbitration finding of liability intact?
My opinion is every one of the cases that came before the circuit court's ruling in this case found that each claim has to be decided on each merits. Now, there was one case that
and each element of each claim?
Not each element. Liability and damages are treated separately.
A claim is one of the elements is the element leading to liability, and the last element is damages of those claims.
Well, for example, if we take the easiest one, negligence, there's duty, breach, and causation. That's part of liability. And then there's damage.
And harm.
And so what I'm suggesting is, and what I think all the cases prior to the circuit's ruling suggest, is that duty, breach, and causation are the liability piece. If somebody moves for trial on that, they get to try.
You haven't given us a case that says you can accept the arbitrator's determination on the liability, but seek a trial on damages on a particular claim. You haven't given us one of those cases.
I think that's what Johnson finds. I think that's also the natural import of Bacon. Yeah. And I think that that's also what the 4th District found in the Broward Yachts case.
And are those mandamuses or are those appeals from a final judgment?
All of them are mandamuses.
And the mandamus was to compel entry of judgment or to compel a trial?
To compel a trial, well, actually, in one case, it was to compel a judgment, and the other, it was to compel a trial on a motion for trial. And that's what the circuit court did here, is it just denied Cuffs' motion for trial. And then it said, and by the way, Cuffs, if you don't accept the arbitrator's findings, Duke's going to have a trial on all issues, including its counterclaims, for which it didn't even move for a new trial on that. The entire import of the ruling of the circuit court frustrates both the language of the statute. It renders about half of the Florida Supreme Court rules inoperable. And it also has the practical outcome of resulting in non-binding arbitration, nearly never reducing the number of issues in the case or resolving cases outside of a jury trial context. Now, the statute itself says that it works with carrots and sticks. It says, look, the advantage of going to non-binding arbitration if sent there is that you may resolve your case. The secondary advantage is you may at least resolve some issues, because if one side or the other loses on an issue, they're going to be made to wager the possibility they'll owe your attorney's fees if they want to go to trial on that issue.
And but Mr. Dunn, the statute talks about a trial de novo. So when you think of a trial anew, don't you think of a trial anew with liability and damages?
Anew on that issue, the same way an appeal de novo, like this court has heard this morning.
The statute says the cause of action. The cause of action, to me, includes all of the elements.
This court hears appeal de novos all the time, and it relies upon the lawyers to lawyer their case and tell the court what issues are still live to be resolved. That's exactly the way the arbitration rule works. A motion for trial relies on the lawyers to decide, these are the issues I want to go forward with. And on top of that,
this judge referred the whole case, all issues, to the arbitrator. Arbitrator came back and decided every issue, correct?
The arbitrator decided the claims. We disagree that the arbitrator decided issues like post-judgment interest.
Okay.
And so, and indeed, there's nothing in the arbitrator's award that even discusses post-judgment interest. There's no evidence in the record that the court has in the appendix. Anybody talked about it, put on evidence of it. And so under this court's Bacon decision, crystal clear. If the arbitrator doesn't say something about post-judgment interest or pre-judgment interest, then the district court or the circuit court is obligated to take that up at judgment time. But going back to the operation of this statute, if it becomes the case that if one party moves for a trial on any single issue, all the other issues are taken up, then the rule serves no purpose at all. In fact, it just ends up serving as a waste of time and resources for all of the parties. Ultimately, the court doesn't need to lawyer for Duke. Duke had an opportunity within 20 days to make a decision. Which of these claims are we willing to worry about a fee shift on, that we're going to move for a new trial on it, and which are we not? And Duke made that call. Now, in the Florida Supreme Court recognizes the interpretation that we're advocating to the court here, because in the rule 1.820, it provides outside, and the statute didn't provide this, the rule added this, that after the 20-day window to file a motion for trial, there's an additional 10-day window to add in and move for any third-party claims. So this makes sense, right? Because if you're a defendant and you're happy with the result, the plaintiff moves for a new trial, but you also had claims against a third party, let's say for indemnity, then there wasn't any way for you to know to move for a new trial on those third-party claims. So you need a 10-day safe harbor window to do that. But if the rule is as Duke formulates here, and as the circuit followed, that anytime a motion for new trial is filed, the entire case is tried de novo, there was no reason for the Florida Supreme Court to provide that extra 10-day window. But the most important feature and factor here from the rules operation is that there is no way to assess the fee burden shift of the 25% if people are provided the opportunity to pursue claims that they didn't move for a new trial on. So imagine if we move for trial and Cuffs and Duke again fails to prevail on their counterclaims. They will have failed to exceed the 25% threshold. But because this court, because under that circumstance, if this court had excused Duke from having to file a motion for new trial, then Duke doesn't have to worry about the fee shift under that circumstance. The operation of the rule requires the parties and their lawyers to be responsible for their case. Another way to look at the 20-day deadline to file a motion for new trial is as a secondary pleading deadline. The plaintiff files a complaint. They decide what claims they want to pursue. The defendant files an answer and counterclaims if they feel appropriate. The case is sent off to arbitration. The arbitrator makes a non-binding arbitration award. Then the parties are given 20 days to decide, okay, which one of these claims do you really feel like you've got a shot of winning? And are you confident enough in your shot of winning that you're going to put your client at risk of fee shifting for the other side? The advantage here is it works around the American rule on attorney's fees. The American rule typically operates to not award attorney's fees except in limited circumstances. So oftentimes there's an incentive for parties to make arguments and claims and counterclaims purely as a defensive posture that they don't really have confidence in prevailing on. The non-arbitration process, as the legislature envisioned it, gives everybody an opportunity to cut out the wheat from the chaff. And when you come back, if the parties want to go forward with the trial on an issue, they got to have some skin in the game. What the circuit court's order here did was completely sidestep that scheme, and therefore it rendered part of the statute unworkable, and it rendered part of the Florida Supreme Court's rule a nullity. Now, to talk about the individual cases, each and every one of the cases, in my view, until a Fifth District case that came after the circuit court opinion here, support Cuff's position, and even the Fifth District Court, I'm going to propose, supports the Cuff's position. I think this court's number one precedent it should follow is the Fourth District's case of Johnson. It has the advantage of being the earliest case that I've been able to find since the adoption of the statute, identifying it. And in Johnson, the court is perfectly clear that a request for a trial de novo is on individual claim. In fact, this is a quote: each claim by this plaintiff against each separate defendant stands alone and can be treated, as indeed the arbitrator here did, entirely separate from and alternative to the other claims. This is a case where the Fourth District issued a mandamus order, conditional mandamus order, because the district court put the entire case to trial, even though a motion for trial was only filed on certain issues. In fact,
but that case, number one, Johnson involved different defendants. So there were defendants who were exonerated in the arbitration, and there were defendants who were not. And what Johnson said was, yeah, you can enforce the arbitration decision against the not exonerated defendants and get a trial de novo against the exonerated defendants, right? But the court also said that you can enforce the court's obligation to enter a judgment against the non-exonerated defendants by mandamus. You haven't asked for entry of a judgment in this case.
Well, at the oral hearing, we suggested.
So to me, that makes a difference about whether you have an adequate remedy by an appeal. Because in that case, you have an absolute right to a judgment against the defendants who were not exonerated by the arbitration award, correct?
I'm sorry, I didn't follow Your Honor's question there.
But there, you didn't have different claims per se, or elements of claims. You had whole different defendants, right?
With
some were
claims.
found liable and some were not in the arbitration claim. And the court said, yeah, you can proceed to a trial de novo as to the ones who were not found liable. But you were not required to proceed to a trial de novo against the defendants who were found liable. As to them, you had a ministerial obligation, court judge, to enter a judgment. Correct?
I see my 15 minutes are up. I read the decision differently than Your Honor.
And I think reading what the decision said, but I get it. All right, fine.
I want to say one last thing before I hand off. And that is, if the court is going to allow, essentially require trial courts to lawyer for the parties that don't move for new trial. Let them handpick claims to bring after the 20-day period. Then at the bare minimum, it ought to be made clear that that Cuffs was entitled to prejudgment interest if they did proceed with accepting judgment as the arbitrator awarded, and that Cuffs is entitled to proceed on a fraud claim in this new trial. If it's indeed everybody gets to bring up all the issues in the new trial and everything that was raised in the arbitration, that should include fraud. I'll reserve the rest of my time.
Thank you, Mr. Dunn. Mr. Lang?
May it please the court. Joseph Lang from Carlton Fields for Duke Energy. Right out of the box, I need to make clear there is not a single case that allows for what Cuffs is trying to do here, which is have a trial on elements, the damages element of certain causes of action, not have a trial on the lien claim. This is all after an arbitration that had a single measure of damages. It's not that there were a different measure of damages for each claim. Single measure of damages. They want to have a cafeteria style choice.
The claims these were all different theories of recovery, correct?
They all arise from the same nucleus. Some are actually alternative equitable claims to a breach of contract. The lien claim is dependent upon, obviously, a wrong such as a breach of contract. So they all are interrelated in that regard, but they clearly are different causes of action. Yes, Your Honor.
Mr. Lang, do we have jurisdiction to hear this case?
You do not have appellate jurisdiction, clearly. Mandamus is probably a closer call because I think if the law were as my opponent says it is, I think there are authorities out there that have provided mandamus, but I think there's a clear remedy.
I think there's been authority for mandamus compelling the entry of a judgment, correct? But I don't know that there's mandamus compelling a particular trial de novo, except Johnson says, you don't get a trial de novo against all the defendants and that the petitioner was entitled to a judgment against the ones held liable by the arbitrator.
That's correct. First, there's not an adequate remedy. There is an adequate remedy at law, but also, as with any original writ, the appellate court typically does not direct the trial court as to exactly how to exercise the discretion in forming a new trial. I think that there are questions as to the mandamus jurisdiction, but there clearly is not appellate jurisdiction here. And I don't think mandamus properly lies here. The question of whether there's jurisdiction to hear this, the argument that's being made falls generally within the scope of a mandamus argument, but I don't think mandamus lies here, if that distinction makes sense.
Well, there's been no request for a judgment in this case. For entry of a judgment. So the only thing before us is whether mandamus lies to compel the court to grant a new trial as to particular issues. or particular aspects of claims, basically.
Correct.
And we don't have any case law that analyzes whether an appeal after from a final judgment in the case would be an adequate remedy, because we don't have that scenario.
We don't have that case, but what we clearly don't have is any case that would present a clear legal right to have the order that is being requested here in mandamus. There's not a single case that would dictate the result that Cuffs is asking for here. And
like in this court, we have a holding that you can't compel a trial on liability while maintaining the damages finding of the arbitrator, correct?
Yes, Your Honor, the Morgan case.
Right. Can't split those up.
Can't do what is being asked here.
Even that was the other direction. He wants the liability finding and then the damages determined in the trial, and Morgan was the opposite. But
correct, it was opposite
splitting those claims apart, essentially.
Correct. And the Venatoff case here, which sometimes is cited, I think your court's Venatoff case sometimes cited for the idea that you can file a motion for a trial for less than all issues. What this court said in Venatoff was that filing such a motion doesn't get your motion stricken.
Right. It suffices as an adequate motion, but it doesn't mean the motion, the theory of the motion is correct.
Correct. And in fact, this court, including you, Judge Northcutt, I believe you were on that panel, the remedy—
That makes me nervous when people say that.
The remedy that came out of that case was a full new trial on all issues.
Right. And they said that asking for less preserved the right to a trial on all.
Correct. I also take great issue with the idea that either of those 4th District cases ordered a new trial on particular issues at the elemental level. The Broward Yachts case obviously was 2 different agreements altogether. The Broward Yachts court made it clear that these were discrete causes of action. They weren't overlapping, not shared measure of damages. The Johnson versus Levine was different defendants, as was noted, but the entire cause of action against the defendants that were going to stay in was going to be tried. It wasn't an element by element approach. And let me be clear what is being asked for here as to what would happen at the end of the day. Cuffs wants to hold on to the arbitration award as to the lien, which obviously the measure of damages was identical to what the arbitrator wrote for every other cause of action. There was a single measure of damages. They want to hold on to the entire measure of damages on their lien claim, and then they want to roll the dice basically on just the damages elements of their other claims and basically double dip if they're successful in ginning up some more damages. They only presented one measure of damages to the arbitrator, and the arbitrator chose, a single measure of damages for every single claim and made it clear at the end of the verdict form that this is not aggregated. This is one single measure of damages for every claim. So Cuffs wants to take that measure of damages, but then go to court and litigate damages, just the element of damages.
So basically what the arbitrator said, essentially found, is that this is how much the plaintiff was harmed. And that harm is the same regardless of the theory of recovery.
Correct. Because all of this arises from the same nucleus of facts.
Right.
And they want to double dip by taking that number, which I think I'm obviously not going to reveal numbers, neither did my colleague, but I think it's obvious that there's disappointment in what that number came back as, which is what is leading to this effort. But Cuffs wants to take that number, and then they want to come and have a trial on damages and basically double dip in the trial court, but only have a damages trial on certain causes of action. They want to go ahead and accept that measure of damages on the lien claim. And that's not what the statute is meant to do. I should note the Dungarani case out of the 5th District. I don't think this court needs to wrestle with that. I don't think you need to embrace it or reconcile it. But I think it's important to note that the 5th District has decided that de novo, a strict reading of the statute, a trial de novo means all issues, open and shut, that there is no such thing as this partial trial. I think this court is
that decision isn't yet finalized, correct? I mean, it's
period of rehearing has passed, and the period,
but it's not, hasn't been released. I mean, we don't know. Maybe they're squabbling internally about it.
I suppose
that never happens here. But
I suppose, but there is no rehearing motion, and there was no motion to invoke the jurisdiction of the Florida Supreme Court. So
the court itself could reconsider the matter if it wanted to. I mean, it's subject to revision and withdrawal. I mean, that's the notice on it. But I get what you're saying. They have made that ruling.
Right. And I don't think this court,
ultimately.
Right. I don't think this court is far from that rule when you read all of the cases together. I need to make the point that the Bacon case, which is, I think, the case that Cuffs most embraces, this issue wasn't even at play there. It would seem that it was if you look at the remedy or if you look at the result, but everything the association was arguing, and it was a slew of arguments made by the association, not one of those arguments was that you cannot file a motion for a partial trial. There were lots of other arguments going on, but the association wasn't saying that if we retry this, we get to try our rent claim because you can't file a motion for a partial trial. And so the court didn't have to struggle. This court didn't have to struggle with the question that we're talking about today when it approved a trial that follows the motion. That's virtually dicta. It is dicta because that issue wasn't at play. In the following case, in the Morgan case, which is where this court said you can't go element by element, the court did wrestle with whether you can have a partial motion, and the court said, no, you can't have an element by element trial. You can't do what you're trying to do.
You can't basically do what used to you would have still summary judgment on liability ahead of time.
Right.
And then there was a time when that was appealable as a non-final order, but that appeal is done away with. But so essentially the issue here is whether you can treat the arbitrator's decision essentially as you would a summary judgment on liability, at least as to those claims.
I do want to make sure, well, if anybody has any other questions on these issues, I definitely want to address them because this is the most important. But I do want to make clear that the fraud claim can't possibly go to trial. It was unpleaded. The only reason it was brought up in the arbitration was because it was an affirmative defense and we would have no reason to object to it. We obviously didn't propose a verdict form that matched their verdict form. And the judge had your verdict form included a claim for fraud with a line for damages, you arguably might have been consenting to that claim being considered, but that's not what you did, correct? Well, we certainly did not do that. And whether that argument holds any water or not, I know that argument was raised in Bacon. Bacon was an appeal of a final order. On mandamus, Cuffs is asking you to order a trial judge to basically grant them leave to amend their complaint. That's not the role of mandamus. This is not a pleaded claim in the case. You can't use mandamus to force the trial judge to allow them to amend. And we clearly didn't try it by consent. But in Bacon, there was a balancing of 8-10 factors that this court lists as to whether it was tried by consent. That was not a mandamus case. You can't do that kind of balancing in mandamus. And I want to make clear on this prejudgment interest idea. They expressly presented their number for prejudgment interest to the judge and asked the judge to consider prejudgment interest. I direct the court to Exhibit 48. We included it in our appendix on page 13. And in their appendix on page 208 is the transcript where they asked the judge to include prejudgment interest. They gave an exact number, they gave a per diem number, they had a Exhibit 48 where they put that on paper, and the judge never said I did it or I didn't do it, but all issues were submitted to the arbitration.
And the arbitrator just listed a total number in each line, didn't break it down.
Correct. In the reply brief, they try to make the argument that you would not put that on a verdict form, and we use jury verdict forms, and prejudgment interest is not something you'd put on a verdict form. Well, you could say the same thing about attorney's fees, and attorney's fees were on these verdict forms. They put attorney's fees for the lien on the verdict form. If this is something that should have been on the verdict form, they could have put it on the verdict form, or the judge may have, for all we know, incorporated it into the general damages number that was awarded. But what we know for certain is that once you submit prejudgment interest along with all other issues to the arbitrator, you can't come back to the circuit court and ask for prejudgment interest. This court has said that. We have all of those cases listed at the end of our prejudgment interest section. Your case is the pharmacy management services case. To close, I want to make clear that the appeal should be dismissed. We think that the petition should be summarily denied, if not dismissed. I'm not sure that.
So let me ask you this in that regard. Okay, assume that we conclude, I think it's pretty clear that we don't have appeal jurisdiction, but we have, and assume that we decide that we don't have mandamus jurisdiction because we think there's an adequate remedy on appeal. So we dismiss this proceeding. Where does that leave things in the lower court? Are CUPS still have its choice pending, or what happens then?
To the extent that is unclear, Your Honor, I will try to clear it up right now. My client is still today willing to accept
the number, right?
The number, not pay prejudgment interest, but my client is willing to accept the arbitration award today. So we don't want that ambiguity to stop the court from, dismissing or
so then
summarily.
Theoretically could at that point opt for a trial on everything, or allow the judge to enter a judgment with the number, I guess.
Correct. I mean, I don't want this to be a 6-month open-ended thing after dismissal, but clearly the judge's choice that was given to CUPS before they filed this, we would allow them to make that same choice for a reasonable period of time after this court would summarily deny or dismiss. To choose to go to a trial on all issues, obviously not fraud. Or
you have though kind of indicated, your argument has brought home to me a kind of another wrinkle in terms of our mandamus power or jurisdiction. And that is, assume that we conclude that we can compel the judge by mandamus to have a trial on the damages stuff. But we don't conclude that we have any authority to direct the judge to do a trial on fraud, because that does, as you point out, requires a somewhat discretionary call on the judge's part about whether it had been tried by consent. Do we just dismiss that part of that aspect of the mandamus? And then where does that lead you guys?
I would urge you not to make that decision on the damages element.
That's a given. I understand. But I'm not counting against you. I'm not counting against you if you answer that question.
But as to the fraud alone, I think the judge has made up her mind that is not going to be added to this case.
And so then the remedy ultimately would be an appeal from a final judgment. Like if a claim gets dismissed in a normal course of lawsuits, if a claim gets dismissed and doesn't go to trial and the interrelated claims are tried, the adequate remedy is an appeal from the final judgment, correct?
Correct. I think the standard of review on that would be abuse of discretion as to whether
But whatever, the review mechanism would be after the case is over.
Yes, Your Honor.
Okay.
I'm happy to answer any other questions. Otherwise, I would urge the court to dismiss this proceeding altogether, or at a bare minimum, summarily deny the petition.
So that you could theoretically revisit it down the road in an appeal. Get it. Mr. Dunn, rebuttal. You're muted, Mr. Dunn. You're still muted.
May it please the court.
There you go.
All right. What I don't think has gotten enough attention here is that the trial court extended the deadline for Duke essentially to seek a new trial. And I want to focus in particular on the counterclaims, right? Duke made the reasoned decision at the end of the 20 days, it's not worth the risk moving ahead with our counterclaims. We may have to pay attorney's fees. Now, if this court, and the statute's crystal clear, there's a 20-day deadline for your motion for trial. So if the effect of the trial court's order is to let Duke continue to move forward with a trial on its counterclaims, it's a direct violation of the plain language of the statute. For that, a mandamus may lie.
Well, you know what? I'm not sure though that your remedy there isn't an appeal from a final judgment, because the only mandamus cases you've given us are mandamus compelling the judge to enter a judgment. You have expressly asked the judge not to enter a judgment. Okay, and so then if the judge has a new trial that is too broad, isn't your remedy by an appeal from the ultimate result?
The same analysis in Johnson as to why there's mandamus jurisdiction to enter the judgment relies on the same language in the statute.
Well,
the statute says it shall enter judgment and orders.
Yeah, you're talking about a ministerial duty, but that's different. It's a different case when you're talking about what is your remedy, your adequate remedy.
I mean, if this isn't a mandamus, then the rule is gutted. All it is used for is a tool for delay. And that's what it will have done in this case. Wasted tens of thousands of dollars.
But you have to admit, Mr. Dunn, the issue here isn't purely whether it's a trial just on your claims versus a trial on the counterclaims. The issue that you're raising is your right to get a trial just on the damages aspect of your claims. And I'm not sure there's case law that would support that.
Well, as you mentioned, Judge, in your questions, it's routine in cases that parties get partial summary judgment on liability. You see in car wrecks all the time. This isn't a summary
judgment on liability case, and the remedy is in those cases, if it's incorrectly done, is an appeal from a final judgment.
Well, and even
we used to be able to get an appeal, a non-final appeal on that issue, but not anymore.
Even under that formulation, Duke doesn't get to try its counterclaims that it didn't move for trial on. And it doesn't get a freebie on those without having to wager attorney's fees because it made the reasoned judgment not to file a motion for trial within 20 days. So if the court comes down to that formulation, that it has to be claims and within claims, it has to be liability and damages, then fine. Then Cuffs gets its trial on the claims that it asserted. We have always claimed that the counterclaim was a distraction. We have always claimed that the liability case is a distraction, that what this case has always come down to from day one is how much money is Cuffs owed. That's why we're seeking a trial on how much money is Cuffs owed. And we treat the lien claim differently because you can only lien for certain amount of damages. The damage amount are not the same. You are only allowed to lien for improvements that you placed on real property, not the benefit of the bargain damages that you can otherwise get in a contract and a tort claim. That's why we see it as perfectly reasonable to say the lien claim has been resolved. Nobody moved for trial on it. And for the value of the improvements made to the realty, that's been decided by the arbitrator. But the benefit of the bargain damages, the other damages you're entitled to under the other claims and causes of action is live. And Duke's decision not to file a motion for trial had to have
the judge refer the entire case, all issues, to the arbitrator. That's what the order is. I went and looked at the order, see if the judge held any back. The judge didn't hold any issues back. Sent them all to the arbitrator.
And Bacon says that language covers claims, that the court would take up prejudgment interest in judgment.
Isn't it a little late for you now to say there's some aspect of the lien claim that didn't go there?
Oh, I'm sorry. I wasn't saying that. The lien claim went there. It's been adjudicated and nobody moved for new trial on it. So yes, I agree. The arbitrator made a decision on the lien claim. What I was disagreeing with is that the measure of damages to foreclose on a lien for improvement to real property is the same as they are under the other claims. They're not. The statute on liening property is very specific on what you can lien and what you can recover on the lien.
I get it. So that's the only reason you would claim that you want a new trial on the lien claim, because the damages number and the elements of it might change.
No, what we're saying is the lien claim and the value of the improvements that we were entitled to lien are final. Nobody moved for trial on those issues.
Okay.
What has been moved for trial on is the damages for the other claim, because yes, I mean, there's no secret to it. Cuffs believes the damage amount was low. In fact, it didn't comport with either side's evidence on damages. And so what we're saying is it makes sense. That damage amount only makes sense if we're talking about the value that you can lien. If we're talking about what we're entitled to under the other claims, we want a new trial on that issue. Now, if this court determines you can't do that, there's going to be a rule that says you got to pursue liability and damages, then fine. Cuffs gets a trial on each of the claims it's pleaded. But Duke can't get a new trial on a claim it didn't even move for new trial on. And if it does, then somehow or another, it needs to have some skin in the game. It needs to worry about a fee shift under the statute or the way the statute requires. Otherwise,
you did not demand entry of a judgment on the counterclaims.
we did. At the oral hearing, we asked the trial judge to enter judgment on the lien claim issue. And we also asked for a new trial on the remaining issues. And remains
on the counterclaims.
No, we've never asked for a trial on the counterclaims. Right. And nobody has, which is why they shouldn't be submitted in our view at the end of the case. The only workable rule, and the reason we get all tied up into spaghetti on these things, and some of these other courts have too, is when the courts have to start figuring out what would be fair for one person to decide or the other. We don't do that with complaints. We don't look at complaints and say, well, I really think the plaintiff. I'm
just looking at what our jurisdiction is on that regard. I mean, you know, the jurisdiction is what it is. We can't say it's not fair or not fair. It just is what it is.
And on that point, look, if these things all have to wait until after a trial, now the rule that's supposed to limit jury trials will have doubled them.
I understand, but it wouldn't be the first time. Marital settlement agreement. You have a trial on whether the marital settlement agreement should be honored, and then you have a trial on the merits of the case. So, I mean, it's same kind of thing. All right, we have run out of time. Thank you both very much. Interesting arguments. And with that, in order to leave, you just click the leave button in the lower right-hand corner of your Zoom screen, and we are adjourned. Thank you both.